Good morning, everyone. I had to check to see if it was afternoon yet. I am attorney Catherine Henry, constitutional attorney, educator, and advocate. I've also served as a mediator and restorative justice facilitator for years as well. A lot of you have been watching the videos I've been doing and checking out the resources I've been posting online for months now. But for those of you who might be a little new to me and who I am, what I'm all about, I'll briefly let you know. I'm a Christian. I am a mother and a wife. I have 4 children. My oldest is a sophomore in college. I have 2 high school seniors, and I have a 6-year-old. I have homeschooled for a total of 6 years now, and I will be continuing to homeschool this year for my youngest child. I am an attorney. I was first licensed to practice law in the state of Minnesota, and when I moved to Michigan, I got licensed to practice in the state of Michigan, and then the U.S. District Court for the Eastern District of Michigan. Then I got licensed to practice in the Saginaw Chippewa Tribal Court, because all tribes that are their own sovereign nation, being licensed here in Michigan or in the United States doesn't do anything because they are their own country. So I became licensed to practice there. That particular one is in Mount Pleasant. And then I became licensed to practice or admitted to practice in the U.S. District Court from the Western District of Michigan. And then most recently, I was licensed to practice in the United States Supreme Court. I have been involved with the filing of several briefs at the United States Supreme Court level, and have been getting into appellate filing at the Michigan Court of Appeals and Michigan Supreme Court as well. But a lot of my practice has been doing everyday legal work, drafting deeds for people and creating articles of incorporation or LLC documents for businesses to get started, filing for bankruptcy, or representing someone going through a divorce. I've represented children in abuse and neglect cases as a lawyer guardian ad litem. I actually started that work as a guardian ad litem 14 years ago in the state of Minnesota. I've served as a public defender for the state of Minnesota, as well as a public defender in various areas in the state of Michigan. In my work in Minnesota, that meant I was doing juvenile delinquency representation as well as representing parents and or children in abuse and neglect cases and adult misdemeanors. I feel like I'm forgetting something. I've done a lot of landlord-tenant, contract drafting, basically everyday kind of stuff. So once all this stuff started happening though, and I had been focusing a lot on just appellate work and then doing restorative justice and mediation for the last few years, I realized I couldn't keep up with a lot of those other pieces. So from now on, it's going to be a constitutional focus all the time, whether it's educating my fellow citizens or advocating for our rights with acts that the legislature is trying to introduce, or filing briefs with our appellate courts. Whatever that may look like, that's my focus from now on, is constitutional law. So with that being said, a big thing, Article 11, Section 1 of our state constitution actually requires anyone who has served in public office to swear an oath to support, uphold the Michigan Constitution and the U.S. Constitution. Attorneys take that same oath, so I have taken that oath in my admission ceremonies, but I have also taken that oath when I served on local volunteer boards for the Downtown Development Authority, Planning Commission. I am now a Republican nominee for Township Trustee in Georgetown Township. So in being sworn in to those past roles or coming up roles, I take that oath very seriously. So, and it's something that everybody needs to know, whether you are the governor of the state of Michigan or somewhere in between, or you're all the way, down to the smaller ends of things like a local school district, school board, or city council, or downtown development authority. You are taking an oath to uphold the U.S. and Michigan constitutions. So saying you didn't know what the Constitution required is not an excuse, ever. In fact, you can be held civilly and criminally responsible under federal law if you are denying anyone their constitutional rights, period. So with that being said, I want to get into what the difference here between the Constitution, laws or statutes, and executive orders are, so we can kind of understand how they play together. A lot of what I'm going to be talking about is to try to go through the points that I've brought up in my most recent brief that I filed with the Michigan Supreme Court. The link for that brief is actually listed right in the description of this video. I also have a link to the documents page on my website, so you can see all the briefs that I've been filing recently, as well as some of the other governmental resources. I also have a link right in the description of this video for the U.S. and Michigan constitutions. But all of those are available right on the website, restorefreedommi.com, which we are also connecting or merging with restorefreedomkh.com as the efforts continue to merge completely what I'm doing with the Restore Freedom Initiative petition and trying to restore our Constitution that way, as well as through my law firm and those constitutional advocacy efforts. So Restore Freedom KH will be the new website, and hopefully we'll have a blending of other things so you can just have a one-stop shop for all of your constitutional needs at that point. So I am jumping to page 7 of that brief that is listed there. And I want us to pay attention to a Michigan Supreme Court case from 1865. Yes, well over 100 years ago, 1865. So in this case from the Michigan Supreme Court way back then, they say that, quote, "Our province is not to make or modify the Constitution according to our views of justice or expediency, but to ascertain the true intent and purpose of the Constitution which the people have deemed it just and expedient to adopt." What they're saying is, it's not the job of a court to go taking an eraser to any parts of our laws or our Constitution. The people adopted the Constitution, and from time to time we amend the Constitution. When we do that, the courts are then bound by whatever the Constitution in effect at that time is. It doesn't matter if they don't like it or not. It doesn't matter if they don't think it's very wise or appropriate, or if they think that it's not fitting to the circumstances. None of that is relevant. Their opinion on that matter is completely 100% irrelevant. What they're saying here, what they explain, is that all that matters is that their job is to enforce the Constitution, to essentially explain what the Constitution says on that particular issue at point there. So they spell out that we, as the Michigan Supreme Court, in common with the people and all the departments of government, every single government official, as well as the people of the state of Michigan, are bound to obey all of the provisions of our state constitution. All of them. We can't pick and choose, even if we don't like them. And that's considering how unwise, in our opinion, they may be. Further, the court goes on to say that it can never be wise or expedient for the judiciary, however pressing the exigency may appear, to disregard the plain principles of the law that the people chose to, in their sovereign capacity, to adopt in order to secure the rights that we have. And they state that the Michigan Supreme Court, the duty of that court is to declare an act of the legislature or executive branch unconstitutional and void if it plainly conflicts with the Constitution. That duty is clear and imperative. There is no way the court can get around that duty. Sorry, I just had an epiphany about a case that needs to be brought, a brand new case that needs to be brought to the Michigan Supreme Court. But anyway, moving on. So I also want us to take a look at the U.S. Constitution, Article 6. The U.S. Constitution and the laws of the United States, so federal statutes that are made in compliance with the U.S. Constitution, those are the supreme law of the land. And judges in every state are bound by them, no matter what, no exceptions. That's written in the language of the U.S. Constitution itself. And anything in the Constitution or the laws of any state to the contrary notwithstanding. So what does that mean? Well, that means that if there is a provision in the state constitution that violates a provision of the U.S. Constitution, the U.S. Constitution rules, period. So, hence the reason for a lot of the provisions that I'm putting into the Restore Freedom Initiative petition. Areas that we need to strip away the extra garbage that has been added over the years to our state constitution that actually violates our U.S. Constitution. Then I want us to take a look at an 1803 United States Supreme Court case you might have heard of, Marbury versus Madison, which explains that any law repugnant to the Constitution is void. Period. Any law repugnant to the Constitution is void. There's a hierarchy for a reason. And courts, as well as other departments, are bound by the Constitution. They're bound by the Constitution. They can't choose to step in only when they feel like they want to. They can't choose to decide that, well, that law or that constitutional provision made sense when it was enacted, but we don't think it's very smart anymore. They don't have that right. They are bound by the terms of the Constitution. In fact, if we look at a U.S. Supreme Court case from 1934, the Constitution meant at the time of its adoption what it means today. It's not this living, breathing document that changes over time to fit the needs of a particularly loud group of individuals within our society today. No, the Constitution meant at the time of its adoption what it means today. The great clauses of the Constitution must be confined to the interpretation which the framers would have placed on them. What did those clauses mean to the framers of the Constitution? The question is not, what does that constitutional provision mean today to an activist, judge, or justice? In fact, our Michigan Supreme Court in a 1865 case spells right out that the meaning of our Constitution was fixed when it was adopted. The meaning was fixed when it was adopted. The meaning does not get to change over time for our state constitution, nor does it get to change for the United States Constitution. The meaning of those documents was fixed when it was signed, when it was adopted. That's like changing the terms of a contract afterwards just because it seems like it might make more sense to do something differently now. If you make a contract with someone, you are bound by the terms of that contract. You can't later on say, well, it no longer makes sense to do this. Well, obviously, something changed in our lives and we need to be able to do something differently than what the wording of this contract says. That's not the way it works. The whole point of having a contract is that I will fulfill my terms of this deal because I know that you are now bound to fulfill the terms of your deal. Period. That's the whole essence of a contract. That is what the Constitution is. Our U.S. Constitution is a contract that our forefathers created with each other to be bound by the terms of it, so that we and all of us before and all of us after are going to be bound by those terms because we are going to be benefited by those terms, because we know that everyone else is bound by those terms. The government, the U.S. government, the state government, and all the other individuals here in the United States, we are bound by the terms of that contract we made. And it's okay that we're not the ones that signed on to it, because the people who created that system of government, the initial signers to that contract, they bound us afterwards because we are beneficiaries of that contract moving forward. Basic Contract Law 101. You can't change it afterwards just because you feel like you want to. It doesn't matter if you're a U.S. Supreme Court Justice, a state Supreme Court Justice, a trial court judge, if you're an attorney general, a governor, a school board representative. It doesn't matter who you are, you do not have the authority to change the meaning or the terms of the U.S. Constitution or the United States Constitution. Not a single governmental body or governmental entity or officer has the authority to do that ever, period. In fact, our Michigan Supreme Court says in this 1865 case that they are designed, state constitutions, are designed to provide for contingencies not foreseen as well as those which are foreseen. Again, reiterating, it doesn't matter what has come up now, COVID-19 or whatever the next newest thing to be afraid about is. Our Constitution was drafted knowing that there are going to be things coming down the pike that we are not familiar with, things that we did not see coming. There's always going to be something we didn't quite see coming. That's okay. That's called life. Suck it up, follow the Constitution, and move on. That is literally what all of this is explaining. In fact, the court goes on to say, the Michigan Supreme Court, the rules of law are supposed to be permanent. So following what the Constitution says, the U.S. and the state constitutions, following what those documents say, and the meaning of following them is supposed to be permanent. It's not supposed to be something that changes over time. A state constitution, they say, proceeds from the people in their original capacity as the source of all power in government. We'll talk about that source of power in just a minute. No attempt should be made to evade or defeat the state constitution or any of its terms. That comes from the words of the Michigan Supreme Court in 1865. They knew this back then. As the skipping an important piece. Its language, the language of the state constitution, must be read with an interpretation that is not interpretive, but rather consistent with the plain, common sense meaning, unaffected by any passing excitement or prejudice. This is a passing excitement. Are people dying of COVID-19? Yes, I'm sure they are. Do people die from the flu every year? Yes, they do. Do people die from domestic violence and suicide and heart attacks and cancer and car accidents and smoking? Yes, they do. Is it the government's job to stop everyone from dying? No, it's the government's job to secure our blessings of liberty, period. And as the Constitution, this is again continuing the language of the Michigan Supreme Court, as the Constitution derives its force from the adoption by the people, we should, in its construction, in reading it, seek only for the sense in which it was understood by them, the people who were voting on it and creating it at the time that they were doing so. So we don't look to the U.S. Constitution and say, well, what does it mean today? No, we look at what it meant when it was created. So, let's see, before I move on to that point. Well, this is a good segue. This is a good segue into why does our Constitution create a separation of powers? Well, there's a separation of powers at the federal level. I'm talking about our state constitution specifically. But the analysis obviously can cut both ways. So if you look at our Declaration of Independence, it says right in there, one of the main reasons why we were declaring our independence was because we had executive usurpation of legislative authority. We had those in an executive role suspending our legislatures, declaring themselves invested with power to legislate for us, to create laws. So way back in 1776, we signed the Declaration of Independence in part because we had people in the executive branch that were trying to create laws which belongs to the legislative branch. That goes to the foundation of why we have a country in the first place. That's not something that can be overlooked. It's not something that's just there to be minimized or mocked in any way. In fact, a constitution's most basic functions are literally to create the form of government and structure of government, to define and limit the powers of government, and to provide for the protection of rights and liberties. Those three things, right? That is found in the Michigan Supreme Court case from 2018. I've talked about that case a lot. It's a citizens case. Citizens Protecting Michigan Constitution. They were suing the Voters Not Politicians group that was trying to amend the state constitution in 2018. So our Michigan Supreme Court from 2018 said, a constitution's most basic functions are to create the form and function of government where we are defining and limiting the powers of government. Limiting the powers of government. Not limiting the rights of the people. Also, to provide for the protection of rights and liberties. The same rights and liberties that are given to us by God, says so in our state constitution, given to us by God, we are protecting those liberties. We're not assigning those liberties or granting those liberties. We are just protecting those liberties that are given to us by another source, God. We're not limiting our liberties. We're not defining our rights and our liberties. That's not the job of the government to do. So with these interests in mind, right? So organizing and limiting government and then protecting our rights and liberties. Our state constitution was drafted with Article 3, Section 2, which not only distinguishes, or I should say, distinctly separates the powers of government into three separate branches, but also specifically prohibits any person exercising powers of one branch from exercising powers properly belonging to another branch of government, except as expressly provided in this Constitution, period. End quote. So we have to be cognizant of all these different arguments that are being made. And people talk about delegating powers and how the legislature delegated their power the um, to the executive branch. You know, they're allowing the governor to create executive orders in times of emergency or whatever, because it would be, you know, the argument is that she could act more quickly. It doesn't matter. Literally, the language of the Constitution says absolutely no delegating power to another branch unless it says so in the Constitution. The only place the governor gets to make law is Article 5, Section 2 of our state constitution, where she is allowed to make executive orders not to regulate the people in any way, shape, or form, but only to reorganize part of the executive branch, which then the legislature has a period of time to decide whether they want to disallow that change. So even then, the legislature can pull the plug on that executive order. So what about the separation of powers clause and the non-delegation clause? Well, our state constitution further defines these distinct and separate powers that the separate branches have. In Article 4, Section 1, that's the legislative power. Article 5, Section 1 is the executive power. And Article 6, Section 1, which is the judicial power. So I'm going to take you to a quote from, let's see, this one is a Michigan Supreme Court case from 2004. The legislative power is the power to determine the interests of the public, to formulate legislative policy, and to create, alter, and repeal laws. The governor has no power to make laws. The executive branch, or governor, may only apply the public policy determined by the legislature. And also, if we look at another Michigan Supreme Court case, this one from 2008, they said that the governor cannot exercise legislative power by creating law or changing the laws enacted by the legislature. They've already explained that to the governor 12 years ago. So there's some interesting arguments that have been put forth, back and forth, right? So when it suits the people, such as the governor, the attorney general, all the individuals that think these mask mandates are necessary and appropriate, they say, well, these executive orders, they're not law. Oh, no, we're not trying to do anything creating law. Absolutely not. It's just all these other things that are apparently still enforceable like law. But don't worry about it. It's not a law. We're not violating the separation of powers. But then they turn around and say, oh, but this is a law. You do have to follow it. And by the way, you can be punished in a multitude of ways for the same act or omission. Could be an omission, right? Not wearing a mask. So let's clear this up. As far as to the point of whether she's attempting to create laws, let's think about this. She places new rules and regulations upon individuals and businesses like they're going out of style. And literally, it is a fast-moving fad, right? Because we can no sooner read one executive order before she has issued an entirely new one to create all kinds of new regulations upon the people and businesses. She is punishing individuals and businesses with various law enforcement tools like jail time, criminal fines, civil fines, and professional licensure revocation. And the governor, in doing this, is attempting to create laws. By setting aside provisions of a plethora of public acts, like the fire code, that was a recent one in the executive orders, I don't even know the numbers anymore. I want to say maybe Executive Order 165, where she was describing what things will be happening in schools and how they're allowed to set aside fire codes so that they can comply with her mandates regarding COVID-19. That's Executive Order 159. She's tried to set aside FOIA, Freedom of Information Act, She did that in Executive Order 38, among other places. The Open Meetings Act, she has set aside in Executive Order 48, as well as several thereafter. So by doing this, she is attempting to change or rescind laws properly enacted by the legislature. Also, something that's very interesting is that we have individuals like, for example, I believe it was an attorney and law professor from University of Michigan School of Law, who submitted an amicus brief in the legislature's lawsuit against the governor. And that brief was submitted at the Court of Appeals level. And in there, he states that everyone agrees that the pandemic orders issued prior to April 30th were valid. Really? I would think that anything that violates our constitutional rights or violates the constitutional limits placed upon the governor, any of that would be unconstitutional and not valid, whether it was March 23rd or whether it was April 30th. It doesn't matter what the time is. She's never allowed to do it. So it's interesting that we have individuals who have their head so buried far in the sand that they don't even recognize this is not just a statute thing. This is not just a timing of, well, after April 30th. Yeah, after April 30th, she then is violating the statute. But to the extent that the statutes go above and beyond and violate our Constitution, they were never enforceable in the first place. So, another thing we need to keep in mind is that, again, this back and forth, right, where we have the governor and those in support of all these ridiculous executive orders saying things like, well, these executive orders are attempting to create law. No, she would say at times they are creating law. Other times she says, no, we're not creating law. We're just having these executive orders. We're not violating the separation of powers. In fact, good point. In one of her most recent orders, I think I have it right here. Let's see. It might be this one. Yeah. Executive Order 2020-160, which, I don't know. I haven't looked in 2 days, so it's possible that she's already up to 189 or something like that. Who knows? But July 29th, when she signed the Executive Order 2020-160, she put paragraph 13, separation of powers. Nothing in this order should be taken to interfere with or infringe upon the powers of the legislative or judicial branches to perform their constitutional duties or exercise of authority. Similarly, nothing in this order shall be taken to abridge protections guaranteed by the state or federal constitution under these emergency circumstances. What she seems to forget here is that, remember how I just said our state Supreme Court made it very clear that one of the most basic functions of a state constitution is to define and limit the powers of government. So she's trying to say, well, as long as the legislature gets to keep making laws, it's no big deal if I do that as well. Yeah, it's a big deal, dude. You're not allowed to make laws. Period. Ever. So she seems to forget that, and she seems to try to spin to make it seem like it's okay because the legislature is still allowed to make laws. She's just joining that lawmaking club with them. And also, similarly, nothing in this order shall be taken to abridge protections guaranteed by the state or federal constitution under these emergency circumstances. Interesting that she has to add that clause as though somehow during a state of emergency our rights protected by the U.S. or Michigan constitutions are somehow set aside. Nope. None of them are set aside. No right specifically protected in our state constitution or our federal constitution is ever set aside, period. To the extent that we have had a president or a governor or a Supreme Court justice or whomever ever say something to the contrary, they're dead wrong. Period. We don't have our rights set aside because something scary is going on. There's always something. There's always a war. There's always a terrorist infiltration. There's always some sort of a bombing or a huge earthquake or tornado or COVID-19 or the swine flu or H1N1 or whatever. What was it? West Nile virus just last October was the big thing here in Michigan. There's always something. We don't get to set aside our rights just because there's something scary going on. Considering that, though, it's funny then that you can hear our lovely governor say things in press conferences like, right now, the law requires that anyone in an enclosed public space has to wear a mask. The law requires, which law was that? In fact, we even have a Cooley Law School professor that is telling the media and individuals everywhere that there's this Whitmer's mask law out there. In fact, then we have Michigan's new law requires people to wear masks as a description of what's going on here. There's no law out there that says we have to wear masks. If there was, it still would not be constitutional, so it would be void. It's as though it doesn't even exist. And I'll kind of summarize that with what I have behind me. So it's important that we recognize our state constitution specifically prohibits, 1, a governor from creating any laws. That's Article 3, Section 2. She certainly can't do that in executive orders because Article 4, Section 22 requires laws to be created by a bill, unless it's one of the provisions that's done through initiative. Laws are not allowed to cover more than one subject, according to our state constitution, Article 1, Section 24. Laws cannot modify parts of other laws without including the entire text of the law of which they are modifying. For example, when she modified the FOIA statutes, she did not completely include the entire text of the Freedom of Information Act. So she's violating Article 1, Section 25. Our state constitution also requires that unless the legislature has voted by a supermajority to give a law immediate effect, the governor has to wait 90 days before enforcing any new laws. She didn't wait 90 days to enforce her new mask law. That's Article 4, Section 27, if you're looking for it. In fact, let us not forget that in many of these executive orders, most, if not all, actually, like Executive Order 2020-161, she literally says things in there like this. Governor Whitmer puts in Executive Order 161, quote, "This order is effective immediately upon issuance." But wait, it's the law, it's immediately effective and enforceable upon us by criminal and civil penalties, but we don't have to wait the 90 days to enforce this law upon us according to Article 4, Section 27 of our state constitution. Also, Article 4, Section 39 of our state constitution literally requires, that whole section requires our state and local government operations to continue in periods of emergency. I'm not making this up. It's in there. Please look at it. So she's done that, but in her executive orders, she's shutting down non-essential government services. By the way, if we have any non-essential government services or non-essential government employees, it seems like a misnomer. I'm thinking that means we don't need those functions of government. We don't need those government employees. Whatever they're doing obviously needs to be done in the private sector or maybe not done at all. When the legislative and executive powers are united in the same person or body, there can be no liberty. That's not just me, a conservative zealot, saying that. Let's see, which one is that coming from? Oh, yes, that's the Michigan Supreme Court in 1982. That was before my time, actually, so I can't claim credit for that. When the legislative and executive powers are united in the same person or body, there can be no liberty. Article 3, Section 2 was included in our state constitution because it was the Constitutional Convention's intent to, quote, prevent the collection of governmental powers into the hands of one man or woman, thus protecting the rights of the people, because he who enforces a law shall not make or change it. How do I know that's why that provision was put in there? Well, it's in the official record from the Constitutional Convention of 1961. It's page 601 if you're looking for it. So what's interesting is that we have people that are arguing that the legislature has chosen to delegate the authority to act in a public health crisis because the executive branch answers to a single authority, the governor, who is uniquely positioned to act quickly and decisively in an emergency. Okay, so she can act quickly and decisively. So then this group of individuals who filed a brief in the legislature's lawsuit against the governor, they are arguing then it's a good thing for us to give all this power, this delegation of power to do these executive orders to the governor, because she can act quickly and decisively on her own. It's a good thing for her to do that, they say, because they point out that the legislature is by design a very different institution. It speaks with many different voices, representing many views, not the single voice of a governor. It acts through the legislative process, which is designed to collect information from numerous stakeholders with multiple viewpoints and gradually build consensus through a process of deliberation and compromise. Yeah, I think that's actually what the process is designed to do, and why. And so far, I'm seeing that as a good thing. However, these attorneys continue by saying, the process by which a law is enacted is purposefully designed to be slow and deliberate, not fast and decisive. For example, the Michigan Constitution explicitly requires that before a bill can be passed into law, it must first be read 3 times in each house and kept in the possession of each house for at least 5 days. Article 4, Section 26. Once these threshold requirements have been met, the bill must be approved by a majority of the members elected to and serving in each house, and then presented to the governor, who shall have 14 days in which to consider it. That's Section 26 and Section 33 of our state constitution. In other words, the legislature can only act through the legislative process by considering multiple viewpoints and gradually building consensus through deliberation and compromise. End quote. Yeah, I would agree with that. Now, for some reason, these people who think that masks should be required upon all humans and that the governor should be able to continue issuing executive orders, for some reason, these people think that these are bad, that the fact that our legislature is supposed to consider multiple viewpoints and hear from multiple people and act slowly in this regard, they think that's a bad thing. I'm sorry, but when it's our rights that are being affected, when they're attempting to regulate us, the people, they should have to do that pretty deliberately and pretty slowly, and in listening to a wide variety of viewpoints on the issue. No one person should ever be able to dictate what we have to do. In fact, that's called a dictatorship. And we don't have that here in the United States. Nowhere in the United States. So I'd like to remind you that as it says right in our Declaration of Independence, we are endowed by our Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. And it is to secure these rights that governments are instituted or created among men, deriving their just powers from the consent of the governed. What does that mean? Well, if you look at Article 4, Section 4 of the United States Constitution, it guarantees to us a republican form of government, which is what? It's one where the people hold the sovereign power. We did back then, and we still do now. We hold the sovereign power, and we elect individuals to represent us. They do not have their own inherent power. In fact, our state constitution, Article 1, Section 1, says that all political power is inherent in the people. It's not inherent in the governor, in the legislature, in the judicial branch. It's inherent in the people. Because we create these constitutions, our state constitution, our U.S. Constitution, as a contract, as a mechanism for ensuring a way that we will behave towards each other to protect the rights that God gave to us. The government didn't give us those rights. They cannot take them away. God gave us those rights. So, a constitution is made for the people and by the people, something you obviously have known for a while, but it's also something that our state Supreme Court reiterated in 2018. And the U.S. Supreme Court in 1992 reiterated that the Constitution and the foundation of all of our laws that it serves as, that foundation does not protect the sovereignty of the states for the benefit of the states themselves, or state governments, or as abstract political entities, or even for the benefit of public officials governing those states. What are they saying there? The U.S. Supreme Court said in this 1992 case, powers are reserved for the states and set up so that the states have sovereignty for the sole purpose of further protecting the rights of the people, not the rights of the state. The state doesn't have rights other than to be able to protect the rights of its people, the rights of its people, not to tell the people what to do. It's not the governor's job to tell us what to do. It's not the legislature's job to run around telling us what we can and cannot do. We create laws to have a generally orderly system of government to keep us from violating other people's rights. To the extent that we have laws that then seek to, the laws themselves are what's violating our rights, those are not permissible. And for those people that still might think that emergencies change things, no, they don't. I don't care what degree you have, what title you have behind your name. If you're thinking that emergencies change the Constitution, you're wrong. Our state constitution, Article 4, Section 39, I already just talked about that. State governments have to continue in times of emergency. State and local governments have to, by constitutional mandate, continue during times of emergency. But also, if we look at a U.S. Supreme Court case from 1934, it clearly states emergency does not create power. Emergency does not increase granted power or remove or diminish the restrictions placed on powers granted or reserved. The Constitution was adopted in a period of grave emergency, and the grants of power to the federal government and its limitations of power on the states were determined in light of that emergency, and they are not altered by emergency. So we also need to remember that the 14th Amendment specifically states that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. They cannot create any kind of mandate, any requirement, any executive order, any law, any statute, any rule, any administrative regulation ever that violates our rights, because those rights are guaranteed to us. Notice it says that states cannot abridge the privileges or immunities of the citizens of the United States. It doesn't say the state cannot abridge the rights of the people that are listed in the Constitution. No, because it also explains in there, in the 10th Amendment, that there are powers created, given to the federal government, and any power not specifically given to the federal government is either saved for the state governments or for the people. But also, if you look at Article 1, Section 23 of our state constitution, it reminds us that just because we have certain provisions, certain rights that are specifically protected in our constitution, that does not mean those are the only rights that we have. God gave us our rights. We create these constitutions to protect those rights, but we don't always think of all the rights that are there, or we don't often think we have to create an amendment or a provision of our Constitution to spell out which rights are protected. Who would have thought, even a year ago, let alone back in 1776, that we needed to create a constitutional provision to spell out the government cannot require you to wear a mask in public? No one would have thought of that. But the government is not allowed to do that because they're not specifically given the power to do so in our state or federal constitutions. Also, there are federal cases that quite clearly explain that the claim or exercise of a constitutional right cannot be converted into a crime. So if you're out there circulating the Restore Freedom Initiative petition and you're not wearing a mask, you're exercising your rights to free speech, your rights to petition your government for a redress of grievances, probably your right to peaceably assemble, and that cannot be converted into a crime. You cannot be charged with a misdemeanor for that. You cannot receive a $500 criminal penalty. You cannot receive jail time for that. You cannot receive civil infractions, because every single executive order that has been issued to restrict our movement, thwart our opportunities to peaceably assemble, to petition the government for redress of grievances, all the executive orders that have impaired our contracts is defunct, along with any statute purporting to provide authority for those usurpations in the first place. Why is that? Because an unconstitutional act is not a law. It confers no rights, it imposes no duties, it affords no protection, creates no office. It is in its legal contemplation as inoperative as though it had never been passed. The United States Supreme Court explained that to us in 1886. If it's not constitutional, it's as though it never existed. Executive Order 160, 161, 162, all of the governor's executive orders that go against the limits placed on the government or that go against the rights that we have been given are unconstitutional and void on their face. So we need to remember that our U.S. Constitution was created to secure the blessings of liberty to ourselves and our posterity. And our state constitution was established to secure the blessings of freedom from Almighty God, undiminished, to ourselves and our posterity. I want to leave you with a couple things. One is to point out some of our specific rights that are being violated, because you need to know what your rights are in order to stand up for your rights. Article 1, Section 3 of our state constitution gives us the right to peaceably assemble, consult for the common good, instruct our representatives, and to petition the government for a redress of grievances. The First Amendment to the U.S. Constitution also gives us the right to peaceably assemble and to petition the government for a redress of grievances. So to the extent that all these executive orders in 2020 have been geared towards keeping the people locked in their homes, forcing them to social distance from each other, making it a crime to gather in groups more than the allowed amount of that moment, all of that is unconstitutional, period. Our liberty to worship God according to the dictates of our own conscience is protected under the state constitution, Article 1, Section 4, along with the U.S. Constitution's First Amendment, because we have the right to exercise freely our religion. But our governor has tried to require that masks be worn and social distancing being used in those worship activities. That's clearly not allowed by the language of our state and federal constitution. While our state constitution, Article 1, Section 5, guarantees that every person may freely speak, write, express, and publish his views on all subjects, where no law shall be enacted to restrain or abridge the liberty of speech or of the press, gatherings have all of a sudden been prohibited. Press and the public have been limited at the governor's press conferences due to social distancing, and Michiganders are punished with harsher executive order provisions when we gather for speeches at public rallies. Clearly, what she's doing is unconstitutional. Article 1, Section 10 of our state constitution protects our rights to make contracts unimpaired. The government cannot impair our ability to follow through on our contracts. Yet the executive orders are directly prohibiting thousands of businesses from being open, thus directly impairing their ability to follow through or perform on a multitude of contracts. It's unconstitutional. We are guaranteed our right to be secured from unreasonable searches and seizures under the Fourth Amendment to the U.S. Constitution, as well as our state constitution, Article 1, Section 11. Yet the newest executive orders require businesses to utilize contact tracing measures, asking customers and employees about their travels and health histories, and taking their temperature, all without being charged with a crime or having a warrant issued. It's unconstitutional. Contact tracing, temperature checking, and asking people about where they've been, who they're related to, and where they've essentially been traveling and what their health history is, that's unconstitutional. We are guaranteed due process of law under the 5th and 14th Amendments of the U.S. Constitution, as well as Article 1, Section 17 of our state constitution. Yet all of these new restrictions placed upon us as individuals and as businesses here in Michigan have been imposed without adherence to any of the constitutionally required processes for creating and enforcing laws. So we're being denied due process. Our state constitution, Article 8, Section 8, guarantees that institutions, programs, and services for disabled individuals will always be supported and fostered. So it's a big thing that we are not unnecessarily excluding disabled individuals from participating in society, right? Yet, we have executive orders that have resulted in widespread denial of services for the disabled, also creating a pervasive impediment for the hearing impaired who read lips to communicate with everyone around them, not just the person to whom they are speaking at that moment. So yes, while at least 2 of her executive orders on masks specifically allowed for individuals to not wear masks because they're communicating with individuals with a hearing impairment, where basically reading lips is required. What about all the other times that we are in society as hearing impaired individuals? So anytime we go into an establishment, a government building, or a private business, and everyone in there, customers or employees or whomever, they're all wearing masks, and we are suddenly and effectively cut off from all forms of communication because we read lips. We don't even necessarily know someone is speaking to us in order to tell them, hey, by the way, I read lips. Could you remove your mask so I can communicate with you? How are we fostering and supporting individuals with disabilities to be able to continue to function in society? We can't just cut off huge segments of our population like that. What about individuals with autism or other disabilities where they are already struggling with communicating with individuals, but then you have an individual who's created yet another barrier between themselves and the disabled individual? How does that help a person with one of those types of disabilities to function in our society? How does that, if we have special education teachers who are wearing masks when dealing with individuals with disabilities, such as being on the autism spectrum disorder, the ASD spectrum, or any one of those other kinds of disabilities where children they literally and physically need to be able to have a better human connection in order to be able to get anything out of those services? How is wearing a mask and further distancing that child from that service provider going to help in any way? Basically, what it boils down to is that we are given tons of rights from God, directly from God, not the government. And only some of those rights we have chosen to specifically protect in our state or federal constitutions. But we still get to have those rights because the 10th Amendment to the U.S. Constitution and Article 1, Section 23 of our state constitution tell us that, remind us of that very thing. However, in stark contrast, no government body or government official can ever act without the express permission and authorization to do so. And where do they get that? They get that from the Constitution. So as a very quick recap, because apparently I get too passionate about these things and keep talking and talking about them. We get our rights from God. We then created the U.S. Constitution and constitutional laws that are made in accordance with the U.S. Constitution. These serve as the supreme law of the land. Then we have our state constitution, which serves as the next thing down in terms of supremacy. In the state of Michigan, the U.S. Constitution, then the state constitution are the supreme law of the land in that order. Then we have our state. I have no idea why. Oh, that's left up from an explanation of how fonts appear. Our state laws. We have legislature enacted laws. We have initiated laws by the people, both of which are procedures that are laid out in our state constitution. And we also have the Article 5, Section 2 ability of our governor to create executive orders that merely reorganize a part of the executive branch, and those executive orders then have to be presented to the legislature so they could decide if they want to disallow them. So if you take a look at MCL 8.8, it spells out those are the only three kinds of laws we have here in Michigan at all, ever. What does that mean? Administrative rules and regulations are not laws. Personal preferences of government officials, like your local building inspector or the governor or anybody in between, not laws. Government forms that require something that's not required upon the people by an actual statute, not a law. Internal operating procedures of a government. Well, you can't exercise that particular right or get that particular kind of permit unless you jump through these 47 hoops first. Those aren't laws, and they're not allowed to be enforced upon the people. Executive orders. Absolutely not. Executive orders are not allowed to be used to create restrictions upon the people because that is literally the definition of what legislation or laws are. And laws, again, do not include executive orders that regulate the people in any way. Period. So please make sure you are reading your state and federal constitution. Please make sure you are understanding what your rights are. Read the whole state constitution cover to cover. Read the whole U.S. Constitution cover to cover. I have those available in the link here. I know this was a longer video, but quite honestly, for those people who want to fight for their rights or don't want the government to take away their rights, if you're going to complain that the government is acting inappropriately, but yet you don't know how to fix it, and then you're going to turn around and complain that I created a video that's an hour and 6 minutes long explaining your rights to you, well, you can't have your cake and eat it too. So either you go ahead and be super excited about all the ways our government is violating your rights, or take the time to learn about this. You don't have to learn about it from me. But I'm out there trying to do my best to help you know how to best fight for your rights. Okay, I'm going to do my best because I don't have anybody helping me with these comments, and it looks like it's not going to show me ones that were older anyway. Apparently someone named Beth called me an ambulance chaser. Right, well, I don't do personal injury, so nice try. So all of the governor's executive orders are illegal. No, not all of them are illegal. So an executive order, she did an executive order to reorganize parts of the executive branch. She's done a few of those this year. In fact, I want to say Executive Order 2020-1, 2020-2, 2020-3. I believe those are all executive orders that rearranged different pieces of the executive branch. And I want to say there were 3 more that came out in the last 2 months where she's been rearranging things within the executive branch. They're not things that are trying to regulate the people. So they are legal and constitutionally permissible executive orders. Okay, so the it looks like someone was saying that in order to make executive orders law, she has to present them to the legislature and then they can decide whether they're going to disallow them. That is true, but no matter what, no executive order that serves to regulate the people can ever be considered law, ever, no matter what. It doesn't matter if the legislature approves of it or not. It's not law. Someone says, we know what she is and has been doing is unconstitutional, but what is happening and what are we doing to stop her? We can talk and teach forever, but action needs to happen. So what is being done? Well, I assume if you're on this page and watching this video, it might be because you know that I've been literally doing a ton of things to change what's happening here and to stop her. I'm filing briefs in the legislature's lawsuit against her to wake up our justices, to put her in check. I am filing briefs in other cases to, again, wake up our judges and our justices, to make them recognize they have no choice but to declare these orders unconstitutional on their face and void immediately, and to thus put her in check. I am also answering all the questions that people have asked me about reporting both the governor and the attorney general to the Attorney Grievance Commission, because they are both licensed attorneys and they should thus be reported for all of their illegal and unconstitutional actions and their numerous violations of professional ethics. Absolutely, they should be reported, and I have been more than happy to answer questions for people that want to report the Attorney General, Dana Nessel, or Gretchen Whitmer as governor of the state of Michigan to the Attorney Grievance Commission. If they are disbarred, that kind of creates a problem for them while in public office. I've also been encouraging and giving information, at least, to individuals about the recall. I've done several videos on that, and I'll do another set of videos next week differentiating and explaining some of those provisions. I've also been encouraging, but also explaining the truth about what's going to happen if you sign and pursue support of the 1945 repeal that's out there. But also, I have encouraged people, any person here in Michigan, any registered voter who wants to go out and try to repeal the 1976 Emergency Management Act, as well as some of the dangerous provisions that are within the Chapter 333 of the Public Health Code, I am more than happy to help guide you on that process, to review documents, to help you along the way. Absolutely, I would support someone in doing that. I can't take on those initiatives right now. Why? Well, because I'm doing all of this, writing all those briefs, and answering thousands of questions every week, not to mention I have the Restore Freedom Initiative constitutional amendment petition that is stripping away all the extra garbage that people have been arguing exists in our Constitution that allows the government to do this stuff. Absolutely not. It doesn't, but I'm clarifying and strengthening the terms that make it clear that those things cannot happen. What can you do about it as an individual? Be a petition circulator. If you want to make sure long-term this problem is fixed so no governor can ever do this again to us and no legislature can ever sit on their hands and allow this crap to happen again, please help us. Circulate the Restore Freedom Initiative petition. Collect signatures. We need 425,059 signatures turned in by November. Help us to do that. And then help us to spread the word so everyone knows, because it will be voted on in the November 2022 election. We need to get the word out there. That is something you can do at home while being a keyboard warrior if you would like to be. But otherwise, getting out in public, you can advertise and spread the word about all of our signing events that we have. You can host a signing event. You can just ask your neighbors and friends and coworkers to sign a petition that does not ever allow the government to do this to us again. You can, I noticed somebody on there said something about donating. You can certainly donate to the out-of-pocket costs we have on this 100% grassroots effort. No government agency or government official in their official capacity is supporting us in any way. No political action committees have been supporting us in any way, which is different than one of the other petitions out there. Actually, two other petitions out there. We are the only petition out there that does not have political action committees financially or in any other way supporting us. We are 100% grassroots, because this is about the people. The people have the power. We are a government of the people, by the people, for the people. This is not a government of attorneys. This is not a government of essentially elected dictators. These are times when you are needed to stand up and do something. So being educated is the first step in that. Yeah, we can teach about it all day long, but I'm not sitting on my butt just telling people about it. I'm standing up there and doing something about it. I even ran for Georgetown Township trustee. I am the Republican nominee for Georgetown Township trustee. Why? Did I have extra time to take on another role? No, I didn't. But it's important. Why? Because our local government officials here in Georgetown Township were not following state laws. They were not following the Constitution. They were acting as though they don't have to follow any kind of notions of accountability or transparency. That's not the way government should work at any level. We need to be working together and as individuals to try to hold our local government accountable, our state government accountable, and absolutely our federal government accountable. So please, if you have any additional questions at all about how to get involved, check out restorefreedomkh.com, restorefreedom, K as in Catherine, H as in Henry.com, and go to the Get Involved page. You'll see a wide variety of ways to get involved. We'd love to have your help. We'd love to have your support. This effort and the time that I'm spending here is not because I love Facebook, because I actually hate it. It's not because I love to have people ask me smart-ass questions insinuating that I'm not doing anything. It's because I'm trying to give you the tools to be able to do it. Awesome. I very quickly saw somebody that said they registered their brother to vote and they're off getting signatures. Absolutely. That's amazing. Thank you. I do want to remind you all, if you try to contact me through Facebook Messenger, I don't have Facebook Messenger. It literally stopped functioning about 3 months ago now. So if you have sent me a message, I'm trying to think of when that was. It might have been the middle of May, maybe. It wasn't functioning at all. It was marking things as read without ever actually having sent me the message in the first place. I don't think it was ever sending messages on my behalf, but it definitely wasn't giving me notifications, nor was it allowing me to go in and open new messages. The more time went on, the more it just began malfunctioning more. Writing comments on these videos, I can only imagine how many comments are on this video. I do my best to see what's here and to answer them, but if I didn't respond to you and you still have a question, please go to restorefreedomkh.com. We have a frequently asked questions page, which addresses, quite frankly, a lot of these questions, and I want to make sure that information gets in front of you. We also have the Contact Us page, so if you're looking for ways to get involved specifically with events or volunteering, or you're a captain or a circulator and have a question in that regard, we have the contact information for our volunteers that manage those parts of our operations. Also, if you are asking me to provide legal advice or guidance or representation on something, there are forms specifically for that. Please understand that I am the one coordinating the whole Restore Freedom initiative. I'm the one that has been answering thousands and thousands of questions every single day. I have not taken one single day off from this. I think the one thing my husband and I did was last Sunday, we finally took a date night. I want to say we were gone for 3 hours from my house to eat and have frozen yogurt. During that time, of course, I'm still answering emails and text messages and trying to get some design work going on our newest flyer that we've put out and posted that summarizes the Restore Freedom Initiative. And a special shout out has to go to, I think, oh shoot, I can't think of what his first name is. It starts with an M, and McCarty? Shoot, I can't remember. Over in the Midland area, one of our circulators' spouses, she's an amazing circulator, helped put us on an event for tomorrow in Freeland. I will be doing another meet and greet, answering questions and whatnot, and it's her husband that designed the flyer. So at any rate, we there's a lot of ways to get involved, so go that route, but please do recognize if you're asking questions of me, you're on the list. I have brought another attorney on board to try to help me sort through and answer some questions, and I am looking forward to being able to provide answers to you. Also, please understand that some of the questions, they're just not that simple. So I don't have an answer about exactly what you should do about a certain thing, because it really depends what is your comfort level with conflict. I personally don't mind taking anyone on if they're violating my rights by violating the Constitution. However, do I want to do that in every single scenario of my life? No. I want to be able to go to the grocery store without being discriminated against because I can't even medically wear a mask, let alone should I have to. I also don't want to have to explain to 47 different people in one day while I'm running errands that my spouse and my children cannot wear masks because I read lips and I need them to not be wearing a mask, if for no other reason than just for me to be able to communicate with them. Because as conversation goes on, they don't necessarily know that they're about to speak and would have to pull a mask down or whatnot. It's just not something we're used to doing. So just recognize that, okay? I'm going to provide answers to the best of my ability. It's a little slower these days because I now have way more people than I ever thought possible seeking advice from me. And I'm willing to do that. And I don't charge for steering you in the right direction or pointing you to provisions of the Constitution or whatnot. But I am still only one person. And the other attorney that I brought on is learning how to best respond to constitutional issues because that hasn't been her focus. So she's doing her best to help me start sorting through that. And hopefully once we get going, we can really start ramping up and answering questions as long as we have an answer to provide at this point. So thank you very much, guys. I know this is definitely a long video, but I want to make sure that I'm really getting you the information. And this was the long video for the week. I kind of violated the rules 2 nights ago when I did an hour-long video on these topics. But from now on, I truly am going to try to follow the pattern of having 2 or 3 really short, very short, no questions being answered kind of videos, where I'm basically giving you a commercial. I'm telling you what the problem is. I'm telling you, why you should care about the problem and what you could be doing, or at least a prelude to the fact that solutions will be offered in a later video in the week. My goal will be to do 2 to 3 of those, and then later on in the week to do 1, maybe 2 medium-sized videos where I'm kind of starting to go into the topics in a little bit more detail, but still not really answering questions, with the last video of the week on the topic being the one where I'm really going all out in detail and then answering questions about the subject. So please make sure to keep all that in mind, that's the format I'm going to try to do from now on. So if you're someone that just wants the little snippets, are you going to know everything that you really need to know to protect your rights? No, because if you want everything in the Cliff Notes version, you're only going to be able to defend yourself as good as what the Cliff Notes version allows. But I am going to try to provide that so at least helps to keep things in more of a summary of things, or to alert you to a topic that you might be most interested in watching the longer videos on. So do keep that in mind, and I will try to do my best to have things announced ahead of time. Even my own team does not know, for the most part, when I'm about to go on and do a video. In fact, I totally forgot to even try to tag anybody in this video. So hopefully they've been I know some of them have been seeing it because I saw that people might be commenting to that, to different, replying to different comments. But it's hard for me to even tell my own team when I'm about to do a video, because quite frankly, this has been my entire life, every single day, 7 days a week, all day long. As soon as I wake up in the morning to literally while I'm falling asleep at night, trying to get the last few emails and text messages out every single day without fail. So it's hard for me to know when I'm actually going to be able to squeeze in the opportunity to eat a meal or when one of my children needs me for something, it's hard to plan around that. And so I hate to tell people, yep, Friday at 4 o'clock, I'm going to do a video. And then sure enough, Friday at 4 o'clock comes. And then maybe that's when the Supreme Court finally returned my call on a pressing matter. That happened the one time I scheduled a video Friday at 4 o'clock. I was sitting here at this desk. I was working on these very issues and totally missed the 4 o'clock time that I told people I would be on a Facebook video. So I'm going to do my best to tell my team ahead of time. I'm going to do my best to tell you, the public, who want to know when those videos are going to be. But please also know that they'll stay on Facebook, and they will also be on my YouTube channel. Usually within a day, I believe, my husband has been able to download the videos from Facebook and upload them to our YouTube channel, so you can see the videos there as well. And a link to the YouTube channel is found right on the RestoreFreedomKH.com website, so please do check that out. Hopefully I've been able to answer the questions. I do see that someone asked if I discussed the petition about the LGBTQ rights. I have not discussed that here. I need to have a video essentially on that thing itself. So next week I will be discussing the series of petitions that are out there, including the one that I honestly did not even realize was still out there. It was not on my radar. And one of our captains in Oakland County brought it to my attention. So I will be talking more in depth on that this coming week. So please keep that in mind to pay attention for that. So someone also saying something about a GoFundMe. I'm not sure if I missed a different comment they were replying to. I do have a GoFundMe. The GoFundMe was set up by my dad. He was concerned about my ability to pay for my law school loans and take care of expenses for my family. The insane internet, phone bills I'm having when I travel around and I do Facebook Live videos to inform people, or, the increased costs of gas or whatever the situation is. We've had my electric bill that I just opened last night was the highest electric bill my husband and I have ever had, and we've been together almost a decade. So those are kind of scary things. Of course, I'm trying to live by faith and not fear, because that's what we are required to do as humans that follow Jesus. So my dad, though, was worried about me, and so created that GoFundMe. So people who would like to donate to the GoFundMe, that is for me personally, for my family, to be able to pay our bills and that kind of thing. We also have the Square ability to donate. If you donate through Square, that specifically goes to the law firm side of things to help me make sure I, have a printer and computer and whatever I need to have functioning to be able to do this work for you, things like that. Filing fees, like this week I had to pay another $75. Well, with the extra online fees, it's $77.25 to file the brief at the Michigan Supreme Court that I talked about today. That's money, I don't have personally. So because my law firm is not taking any new clients, with the exception of, so far just one constitutional case, I will begin taking others as soon as I can get the ground underneath me a little bit more in terms of the Restore Freedom Initiative petition and the matters I'm already handling. But in the meantime, I haven't taken on any other money earning cases. So being able to pay for those court filing fees and be able to keep buying paper to print off all these motions and pleadings that the governor and other entities are filing with courts, it takes money. So that's where the Square donations go to. And PayPal donations are directly to the Restore Freedom Initiative constitutional amendment petition, those out-of-pocket costs. So we will start to have, hopefully, and not too long from now, some yard signs to get the word out about signing events or different things. We've had to pay for thousands of dollars of printing costs, those kinds of things. So That's what each of those are for, and each of those are also described on the restorefreedomkh.com website, so please make sure to take a look at it. Again, I think I've been able to see all of the questions. Oh, you guys are asking some good questions that I don't necessarily have. Our email is not restorefreedom@gmail.com. That one was already taken. So I noticed somebody was trying to help and provide our email address. I'm just going to hide your comment. I think, who is this? I'm going to say your name wrong. Luciana Antonelli. Thank you very much for trying to answer that one question. I just hid that because I'm not allowed to go and change it. Our email address, though, is not restorefreedom@gmail.com. We have restorefreedommi@gmail.com, restorefreedomkh@gmail.com, and then if you go to our website, it lists the others: Restore Freedom Volunteers, Restore Freedom Captains, and Restore Freedom Events at gmail.com are also other email accounts we have. The old website is still there. It's restorefreedommi.com. Restore Freedom KH is going to the same place. Restore Freedom KH, Restore Freedom MI both go to the same place. I'm trying to officially and finally merge efforts of the various things I'm working on because I am only one person, so I apologize if I made that unclear to you. If you type in restorefreedommi.com, it's going to bring you to the right place. But Restore Freedom KH is where I'm trying to get people to type in as the new address. I feel like I missed something. There's an accountant here who is offering to help. If you can help in any way, that would be great. The best way, I don't know what way you were talking about helping because you mentioned that area. I must have not seen another comment you made. Our restorefreedomkh.com website has a Get Involved page, of course. You can offer to volunteer in a variety of ways. We would absolutely love your help. Even if you're an attorney or a paralegal, a legal secretary, and you're willing to come on board and help me, absolutely. Please go to that Get Involved tab of our website and fill that out. There's a section just for legal professionals who are willing to help with this initiative or to help answer questions for people. We would love to have that. What do I think of Unlock Michigan? I'm going to address the Unlock Michigan's petition this week. I've already done videos on that, but I'll do another one to address things as new questions continue to come up, or the same questions continue to come up for new people, I guess I could say. So I will address all of that this coming week. Thank you so much. I think I've scrolled to the end. I don't see any new questions coming in, so I would absolutely appreciate any one of you that's willing to volunteer for our efforts. We totally need to do this as a group effort. Absolutely. I can't do this on my own, and our core group of 15 individuals, we can't do it on our own. We need your help. Absolutely. So thank you so much. I hope you guys have a wonderful week. God bless Michigan.